Hello, everyone, and welcome to Uncivil Law, and I hope you're having a great day. For today's stream, we turn attention once again to the Karen Read case. This time, we are in federal court on the writ of habeas corpus. Karen Read is in federal court arguing that double jeopardy has attached under the Fifth Amendment to the Constitution, and therefore she cannot be retried. This is due to the jury, at least in her view, having reached a verdict, although one was not announced in court and thus would bar retrial. We have taken a look at this case before, and we see some possibilities for Karen Read. She has a difficult time, but not an impossible one under the relevant standards, as we've sort of discussed and debated, with various interplays of how habeas relief is viewed in federal court, which is, of course, where we're at. So we're going to take a look at this reply and see what it says about the thing and see if it changes our assessment in any way. So let's go ahead and get started with this. On the first issue raised by Ms. Read's petition, namely the existence of manifest necessity to support the mistrial, the question before the federal court is whether, as a matter of the federal constitutional law, a criminal defendant may be retried when where the record reflects no consideration by the court of any alternatives to declaration by the mistrial. The trial court was never consulted with counsel regarding its intention to declare a mistrial or even mention the possibility of mistrial in open court. And the court precipitously declared a mistrial and discharged the jury without evidencing any consideration of defendant's valuable right to have his or her guilt determined at a single trial. Under binding First Circuit precedent cited below and in her initial memorandum, Ms. Read respectfully submits the answer to that question is no, and not completely without cause. Incidentally, as we've sort of discussed, the judge acted in a manner that might not necessarily be proper. Now, it's not necessarily as precipitous as some of the case law would sort of indicate. In prior situations where judges have declared a mistrial precipitously, it has been pretty precipitous, right? It's just basically been a bolt out of the blue, something that's kind of unexpected, just like, hey, surprise mistrial, and everyone's sort of caught off guard. But that wasn't quite this situation, although mistrial had not been openly discussed in court before. As we've sort of discussed, there was the Allen charge, or as Massachusetts prefers to call it, the Tui-Rodriguez charge, the Deadlock instruction, the dynamite charge, the please try harder, we'd really like it if you could come up with a verdict charge. And we kind of know from the case law, from cases like Allen and Tui-Rodriguez and others, that once you give that instruction, that's sort of the last step. Because if the jury comes back and be like, we're still not sure, then basically we're all going home, right? Basically, it's mistrial time. So it's not completely unexpected because this idea of mistrial should have been teed up by the Tui-Rodriguez charge. So the defense being like, we were totes surprised, though, is not quite as evident here as it is in some other cases where that has been more of a factor. But that is, it's not irrelevant. It's just not quite on point either. So it's a little off, but that's okay. It doesn't have to be perfect. That's the nature of argument, right? So let's read a little bit more about this issue. And I only have one page of the PDF. It only downloaded one page of the PDF, and I look incompetent. That is exciting for me. I only printed one page. No problem. I will fix it. Give me a second to re-download it. Talk amongst yourselves while we pretend that I know what I'm doing and I'm a competent streamer. If you could pretend that I'm a competent streamer and that you like the stream, that would be really appreciated right about now. Thank you. Lord. I don't even know how I only downloaded one page. That is, how did I even do that? Technically, I don't know. Okay, and where's my PDF that I just downloaded? Windows is not being my friend right now. Lame. Man. View, let's see. I need the details so I can sort by date. Okay. Are you a 20-page PDF? Great. That looks more promising. Let's look at the other 19 pages. That might be exciting. Maybe we can look at the other 19 pages before reaching a conclusion. Lol. All right. In an effort to avoid this result, the respondent largely, and the respondent, of course, in this situation is the government, the respondent largely relies upon procedural arguments that are directly contradictory to binding precedent. Whether there is manifest necessity to support a mistrial is a question of law, not a factual finding for which deference to the state court is due. The First Circuit first expressly held so in Brady. So this was an interesting point of contention, whether there's manifest necessity or not necessarily. Well, okay. The ultimate question of manifest necessity is ultimately a legal question. I agree with that. So the ultimate question of is manifest necessity present is a legal question. But whether, for example, as part of that question, whether the judge considered sufficient alternatives might be a question of fact. So, right, because manifest necessity ultimately is a legal standard. And then you're looking at, well, how do you determine that legal standard? What factors do you look to determine that? What factual elements do you look to? And so one of the factual elements might be, did the judge give sufficient consideration to alternatives? Right. And so that element might be a factual determination, even if the ultimate question, manifest necessity, is a legal one. So they're correct, but I'm not sure necessarily that it goes where they want it to, but that's okay. Similarly, in the context of this petition under 28 U.S.C. 2241, 2254's restrictions on the scope of the court's habeas review, central to the Supreme Court's decision in Renico, which we read that is so heavily relied on by respondent, are clearly inapplicable. I wouldn't go so far as to say inapplicable. It's relevant, but it is not dispositive, which is very good for Karen Reed. So this was a huge issue dealing with the habeas relief, and something that took me a little bit of time to get my hands on. Because normally in a habeas review, we're normally under section 2254, which is a very restrictive section. But we're not under 2254, we're under 2241. And so those restrictions don't appear to apply. And the First Circuit has even held as much, although the 10th Circuit, for what it's worth, actually went the other way and said they do apply. So there's a circuit split on this issue. But we're in the First Circuit for the moment. So the First Circuit rule is obviously the one that guides the First Circuit courts. So very good for her that those restrictions under the Anti-Terrorism and Effective Death Penalty Act do not apply, because if they did, she'd be doomed. Right? She would have to find clearly established Supreme Court precedent in order to win. And there just isn't any. There just isn't any, right? So the Commonwealth, or to the point rather the court, the Attorney General who's filing in court, in the federal court, the Attorney General can obviously say the Supreme Court precedent is relevant, but it's not as dispositive as it would have been if we were under a different section of law. So, it's not quite inopposite or clear. It's not inapplicable. It's just not necessarily all there is. So that's nice. Respondent concedes as much while at the same time relying heavily on case law that are heavily dependent on those very restrictions, which, it's the Supreme Court though. So, I mean, it's something. It's not necessarily controlling in this particular situation. The Supreme Court didn't say you can't do it. But they said that, there is no particular uniform standard, so it's something. Finally, the respondent, like the Supreme Judicial Court, takes the position that no possible showing, no matter how compelling, that the jury unanimously, unconditionally, and with finality agreed to acquit the defendant, but failed to announce such an acquittal in open court could ever entail the defendant to a post-trial judicial inquiry, whether by federal or state court, to substantiate the fact of the acquittal when the acquittal was not reached but not announced. Well, we don't need to ask the jury if the answer doesn't matter. That's what the Commonwealth has been saying, right? So we are presuming, for the sake of argument in this petition, that all 12 members of the jury, if they were asked, would say that yes, we were unanimous as to not guilty. That's what we really thought in our heart of hearts when the judge declared mistrial. At that moment when she brought us in and said, case dismissed, at that moment, we all thought not guilty. That we're all presuming that to be true. But there's no reason to ask if the answer doesn't matter. And right now it's not clear that the answer matters. So there's no reason to ask. So it only matters, there's only a reason to do the inquiry if the answer matters. So yeah, that makes sense why it's like we don't need to ask because the answer doesn't matter at the moment. Post-verdict juror voir dire are required where a defendant has met their burden of production, showing high probability the jury reached a final unanimous of guilty and no precedent cited by respondent prohibits either this court or state judge from conducting an inquiry. There's nothing that prohibits it. I would agree. There's nothing that prohibits it, although there's nothing that seems to require it either. All right, cool. As noted in Miss Reed's opening memorandum, ordinarily a motion to dismiss on double jeopardy grounds rests on a pure question of law. This court's reviews de novo. Of course it does, right? The ultimate question here at the end of the day is what does double jeopardy mean in the Fifth Amendment, right? What does that mean? And that's, of course, a legal question in the end. Like, what is double jeopardy? What is it? And for example, when a jury thinks in their own mind, not guilty, is that double jeopardy, right? That's ultimately a legal question. So of course it's reviewed de novo by the federal court because the federal court is in charge of federal law. No surprise. So the federal court is the one that determines what the Fifth Amendment means. Great, moving on. But the respondent seeks to avoid the merits of the legal issue, reportedly citing purported factual findings by the state court on the issue of manifest necessity. They may very well be factual findings that are relevant to that issue. So yeah, I think they might be factual findings. Now, what does that mean? Of course, ultimately in the end is a legal question, but did the judge consider sufficient alternatives? Did the judge give sufficient consideration alternatives? Might be a question of fact rather than a question of law. So, and then what does that mean? I mean, it's a whole other set of issues, but yeah. But this underpinning of the opposition is contrary to binding First Circuit law holding the inquiry into a trial judge's discretion and the existence, though not a manifest necessity, is a question of law, or at most, a mixed question of law or fact. Not a habeas corpus factual review. Well, if they had just said a question of law, then I would have been like, great, that's fantastic, right? If it's purely a question of law, then that would have been fine. But of course, it's a mixed question of law or fact, which then gets us back to trying to slice the difference where the fun happens. So yeah, okay, fair enough. Pressing on. Along similar lines, while nominally acknowledging the 2241 petition is not subject to the structure of 2254 as enacted by the Anti-Terrorism and Effective Death Penalty Act, respondent argument proceeds as if it were a 2254 case. I don't know that I agree with that characterization. They didn't really treat it like it was. I don't think I agree with that characterization, but okay. Its legal authority, Renico versus Lett, U.S. Supreme Court, arose in that context. Okay. Respondent's contention that Renico is not distinguishable on that basis because it's a rejection of a multi-factor task for determining whether a judge has exercised sound discretion in declaring a mistrial was based on the court's double jeopardy jurisprudence, separate and apart from the additional deference required under 2254, simply cannot be squared with Renico itself. The very first words of the Renico legal analysis were, "It's important at the outset to define the question before us," always important in law. Right? What is the question? Is mostly the game. What is the question is mostly the game in law. And so it's very, very important to know what the question is and keep your eye focused on the ball. Yeah. If you want one skill as a lawyer or one skill as a legal person, right? What exactly is the question? Is a big deal. Yeah, so the question, according to the Supreme Court in Renico, was not whether the trial judge should have declared a mistrial. It's not even whether an abuse of discretion for them to do so, the applicable standard on direct review. The question, rather, under AEDPA is instead whether the determination of the Michigan Supreme Court there was no abuse of discretion was an unreasonable application of clearly established federal law. Yeah, I mean, to some degree that's true, and to some degree not necessarily, because of course the Supreme Court is in the position to determine what clearly established federal law is now, isn't it? And so when the Supreme Court of the United States said that there is no multi-factor test and there's no particular requirement, they might have been saying that in the context of AEDPA to some degree, but I don't think you can't say that it doesn't bleed over. And I'm not even sure the First Circuit would disagree with that, because even the First Circuit, in its case that Karen Reed cited, said there is no mechanical rule. So the Supreme Court said there's no mechanical rule. It's not necessarily that you have to have the jury deliberate for a minimum amount of time. It's not necessary that they, explicitly say, the judge explicitly say what their reasons for declaring a mistrial is. It's not necessary that the judge necessarily consult with the attorneys, and so forth and so on. So none of those things are necessary as a proposition of federal law. Their absence or presence is not dispositive. It doesn't dispose of the case. So that's the clearly established federal law, right? I mean, that's true under AEDPA, but it's also just generally true. There just is no, and even the First Circuit doesn't disagree. They said there's no mechanical rule. The Supreme Court said there's no mechanical rule. So everyone agrees there's no mechanical rule. So, I mean, I wouldn't go that far, but okay. Notably, the court characterized this as a substantial higher threshold for attaining review than de novo. Yes, in the AEDPA, you do need clearly established federal law, and they're like, there isn't any. And by the way, let us tell you what the clearly established federal law is, just in case you were unclear, right? So it's true that Karen Reed does not need clearly established law by the U.S. Supreme Court. She's got that going for her. She does not need a Supreme Court opinion that says she's right. She would if it were 2251 or 2254, but she doesn't under 2241. So she doesn't need to find a Supreme Court case that says I'm right. But of course, the Supreme Court, it's not like it's suddenly irrelevant, right? That isn't true. Renico repeated its closing quotes about not whether the Michigan Supreme Court opinion restating was correct, that rather was clearly unreasonable. Right. Under that posture, that's true. In addition to imposing an onerous standard on review of petitioners, 2254 also severely restricts the scope of authority on which they may rely. The statute requires an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States. So if you're already convicted and you're on a habeas review, yeah, it's you better hope there's an opinion of the Supreme Court that tells you you're right. Right? You better hope there's an opinion of the Supreme Court that tells you you're right. Otherwise, not so much. It's really hard. It was based on the statutory provision, which bears repeating. Respondent concedes is inapplicable here, that Renico expressly rejected. Petitioner's reliance on Sixth Circuit precedent analyzing whether the judge heard the opinions of the parties' counsel about propriety of mistrial, considered alternatives to mistrial, and acted deliberately instead of abruptly. The Sixth Circuit case law did not constitute clearly established federal laws determined by the Supreme Court. Of course it didn't, right? Of course that three-factor test by the Sixth Circuit is not the Supreme Court. So any failure to apply decision could not provide any relief under AEDPA. Right. True enough as far as it goes, but of course the Supreme Court is the one that determines what the Supreme Court clearly established law is. So they're like, yeah, the three-factor test has never been established by the court. And by the way, let us spell out what the precedent is, which by the way is, as far as the Supreme Court is concerned, there is no clearly established dispositive thing. There is no particular thing you can necessarily point to and say, like, this thing is missing or this thing is present, therefore I win. Can't do it. Can't do it in manifest necessity. Now, that isn't to say that there aren't Supreme Court opinions that you can rely on. You just simply can't say this thing or that thing, therefore I win or therefore I lose. It's not that clean. It's a little bit more floaty or a little bit more nebulous than that on the Supreme Court law on manifest necessity. That's just where we're at. Cool. Pressing on. All right, let's see where we are. As the authorities cited in Ms. Reed's opening memorandum make clear, the First Circuit, like the Sixth Circuit, has adopted the three-factor inquiry regarding whether declaration of mistrial is supported. I don't know that I exactly quite agree with that, because even the First Circuit in that opinion said there is no mechanical rule. So the three-factor inquiry can't be a mechanical rule because there is no mechanical rule. This is just some factors to ponder. Now, that being the case, however, right, the three-factor test is still like the best thing there is. So it isn't necessarily the case, and it can't be necessarily the case because there is no mechanical rule. It isn't and can't be the case that, if all three factors go your way, you win, or all three factors are against you, you lose. Because if that were true, it would mean it's a mechanical rule, and there is no mechanical rule, so it can't mean that. But that being the case, however, if you fail all three elements, right, you better have some really good other reasons in your back pocket why you win. So it's not impossible, but it's like, okay, what else you got, right? Incidentally, by the way, this would be somewhat comparable, although the analogy is obviously somewhat off, but I'll bring it up anyway. It would be somewhat how about this? Another example where this would be true would be fair use in copyright law. Right. So if you go read 17 USC 107, which talks about fair use, it will even tell you that it will give you four factors, and it will even say in the statute, by the way, these are not the only four factors there are. But you better believe those four factors remain incredibly important, right? Those remain the most important factors. So is it possible that there's a fifth exciting factor that you could bring in that could blow the whole thing open? Sure, it's possible. But if all four factors are going against you, good luck, as they say, right? Good luck, as they say. So is the three factors the game? Not necessarily, but it's kind of close. So there's that. Respondent appears to integrally take Ranco as license to ignore the foregoing authority, which it does not cite at all in the issue of manifest necessity. In the context of 2241, however, the First Circuit's construction of federal double jeopardy protections is binding, which I agree to that. That is true. The First Circuit opinion is binding. That's true, because that's the nature of the thing. So the federal court must, in this case, apply the First Circuit precedent. So the three factors are definitely going to be something on the judge's mind. And if you have reasons beyond that, they better be good. So, there's that, right? Okay, cool. Re-prosecution is barred because there was no manifest necessity to declare a mistrial on the counts to which a jury was not deadlocked. That heading implies that partial verdicts are required, which I don't believe is true, and there's not even a First Circuit case that says that, right? So again, the Massachusetts state rules, incidentally, say if the judge asks for partial verdicts that they must enter them. But of course, we're on a federal rule right now, so the Massachusetts state rules don't really matter. So as a matter of federal law, not the state level rule, if the judge had brought the jury in and said, hey, by the way, do you have verdicts? And they say, okay, we're not guilty as to 1 and 3, but we're not sure as to 2. Can the judge say, that's not good enough? I'm declaring a mistrial across the board. There's no prejudice as to any counts. Counts 1, 2, and 3 remain live for a new jury. Maybe they can do it better. Can the judge do that? And I don't know of any authority that says they can't, at least as far as the federal rules are concerned. So you say this, it's like, oh, there's no manifest necessity to declare it when they're not deadlocked. That sort of implies they're required as a matter of federal law to hear partial verdicts. And if that case exists, I really wish you'd cite it. That would be great. The question facing this court is whether, applying the foregoing First Circuit precedent, the Commonwealth established a burden of establishing manifest necessity. The answer is clearly no. Okay. Legal mind friend Karen Colin says, it was wonderful seeing you live educating with us with attorney Marilyn Lee Little. I enjoyed my stream with Melanie Little very, very much. And it seems many of you did too. The comments in the live stream, as well as the comments in the chat comments, were overwhelmingly positive. You know, there's some detractors, but what are you going to do? You can't make everyone happy. But, you know, people seem to overall appreciate our chemistry, which I also thought was quite good. And so I really enjoyed the stream, and it was fun. And I hope that we can do it again on another occasion. It was a good time. The record independently establishes the trial court did not consult counsel regarding declaration of mistrial. Fair. At least, yeah, fair. First, the record makes clear the trial court did not give counsel an opportunity to object or discuss with them the availability of mistrial. That is not the same thing, right? That they did not consult and did not give an opportunity are not the same thing, but nice sleight of hand. Neither the court nor either party even mentioned the possibility of mistrial until the judge sua sponte declared one in the presence of the jury. Yeah, but you gave the deadlock instruction though, right? You gave the deadlock instruction though. So I'm having, again, we were totes surprised. We were caught off guard though. I don't know, man. I don't know. That's it. That's no. Respondent argues that assuming federal law requires consultation with counsel, which as a matter of the Supreme Court precedent, it doesn't. In the Renico case, it doesn't. Although it's a factor in the First Circuit case. Counsel for Ms. Reed could have objected or at least be asked to be heard on the matter while waiting for the jurors to enter the courtroom. It bears repeating that this was a mere 30-second interval, during which counsel could not have known precisely when the jury would arrive, or once they did, what the court intended to say to the jury, where the court intended to question the jury, and whether the court would consult with counsel when deciding how to respond to the note. I don't buy that argument. I'm sorry. The judge literally said, I'm going to declare a mistrial, right? So we didn't know what the judge was going to do when they brought the jury in. Really? Really? You didn't know if are they going to consult with us? Are they going to poll the jury? The judge literally said, I'm going to declare a mistrial. I think there might be some subtle clues as to what the judge is about to do, man. You know, I don't think you can claim totes surprise though. Not in this fact pattern. I'm not buying it. And they're like, it's a mere 30 seconds. 30 seconds is a fairly long time, to be quite honest. I mean, you don't even get that long, right? When you're talking about an objection, right? If a witness is on the stand, and something wrong happens, how long do you have to object? About 2 seconds, right? Because if you don't raise that objection right away, we're moving on to the next question. And the judge is going to be like, well, why didn't you object, right? So normally, how long do you have to object? About 2 seconds. How long does it take you to stand up, right? So 30 seconds in the context of a period to object is not like the shortest period of time I've ever heard of in my life. The Jeopardy music was we didn't know how long it would take the jury to get back. Well, I mean, you've seen the jury come in and out of the courtroom before, right? You've seen how long it takes before for the jury to get into the courtroom. So you do have some vague clues about how long it's going to be. And even if you didn't, you had 5 seconds. So 5 seconds was enough in fact, probably. So, fair. In any event, respondents' claim of the mere theoretical possibility of an uninvited objection during the interval was sufficient is foreclosed by precedent. Okay. In Ramirez, after taking witness testimony regarding possible defect in the jury veneer, the trial court declared a mistrial without consulting defense counsel or prosecutor. The jury was brought in thanks for their service and discharge. The First Circuit held this not constitute a sufficient opportunity to object for double jeopardy purposes, even though counsel, no less in the present case, could have lodged an objection or asked to be heard after the court states declaration of the mistrial. Yeah, but is it of even posture? Is it of even posture in Ramirez? So let's pull that up real fast, and because that case. Yeah, I don't. It's like, what was the situation there with the thing? It's like, is it after that instruction, and was it by surprise, right? So the fact, the case is not this factually the same. So sure, in Ramirez, in that situation, then they didn't consult defense or prosecutor, which isn't necessarily good. But is it on the same posture? And it's like, I don't think it is. So I don't think that's on the same. The First Circuit held that didn't constitute a sufficient opportunity to object. In fact, in Ramirez, unlike the present case, the court had, prior to witness testimony, already asked counsel for their position regarding mistrial. Oh, so that is the missing juror case. That is the missing juror case, Ramirez, which we've cited and talked about, right? So yeah, they talked about the possibility of mistrial, but it still was, there was no like button on that to be like, oh, this is happening now. And plus, also in Ramirez, the judge, every time the lawyer did try to object, the judge just said, sit down and shut up. So the defense lawyer did try like 2 or 3 times to stand up and say, Your Honor, and the judge is like, sit down and shut up. And so, yeah, you deprive defense counsel of the ability to be heard, right? Which is not quite the same thing. It's not quite on point. So, yeah. Similarly, in Brady, the trial court, shortly after appointing standby counsel, heard the defense outside the presence of the jury regarding an order it had issued to govern the conduct of the trial. When defendant's arguments became argumentative, the court ordered a mistrial. Given the jury was not present, defendant or standby counsel could have theoretically objected, but the First Circuit nonetheless found insufficient consultation. These precedents are dispositive here. I know you wish they were dispositive here, but I don't agree that they're dispositive here. They're not irrelevant. They are relevant. They're binding as far as they go, right? But of course, every case has its limits, and you have to sort of say as a lawyer, or as a judge for that matter, like, how analogous are these cases, right? The more analogous they are, right, the more likely the cases are to apply, right? So if you have a case that, is, button for button the same, then great. If it's a one-to-one match, then great. But that doesn't happen a lot in law. It happens sometimes, but it doesn't necessarily happen all the time. So it's like, okay, these First Circuit precedents that say, okay, in these situations, that we determined that there was not sufficient opportunity or there was manifest necessity. Is that relevant? Of course it's relevant. It's relevant authority. It's binding authority at that. Is it dispositive? I'm going to go with no, it's not dispositive. It is suggestive, it is relevant, it is persuasive, it's binding, but not so far as dispositive, no. In fact, unlike the present case, the trial court in Ramirez and Brady stated their intent to declare a mistrial before calling the jury, providing more of an opportunity to object than the Ford and Miss Reed. Yeah, but contrary to respondent's suggestion, whether counsel had an adequate opportunity to object is a question for the court to decide, applying foregoing First Circuit case law to transcripts and video footage of proceedings, because it's ultimately a legal question, right? Is that enough? Is that enough? And so that might be a legal question, sure. So is that a sufficient period given everything else that happened? Is that enough? Yeah, that might be a legal question for the First Circuit. That's not an unreasonable posture. In doing so, the court is not bound by any purported credibility determination by the trial court. Well, I disagree with that. I mean, the credibility is a factual question, so they are bound by that factual determination. Maybe it's not relevant, but I wouldn't go as to say so far as to say they're not bound. They can be bound and it also be not relevant, but I think they're bound by it. And then they cite a case rejecting a district court finding as to an officer's statement during recorded interrogation as clear error, because the court's reviewing the record led to conclude that it was clear the officer made the disputed statement. Yeah, so they're challenging a finding of fact in the appellate court, which is like totes hard and basically impossible. But, sometimes. So in that case, in that First Circuit case, the judge said, no, it didn't happen. And the Court of Appeals or the First Circuit was like, but we have the videotape and it's like right there though, right? So your finding of fact makes absolutely no sense. It's batshit nuts because we got the tape. We don't know what you're talking about. So yeah, in that First Circuit case, you appealed on a finding of fact and won. Cool. That's not going to happen here or basically ever. So, no, but okay. See also, for example, a U.S. Supreme Court case granting summary judgment on the grounds that respondent's version of events was so utterly discredited by a videotape that no reasonable jury could have believed him. Yeah. I mean, basically, right. Yeah, you're appealing on a finding of fact. No reasonable jury could believe this. No reasonable jury could possibly believe this. Yeah, you want at the Supreme Court on a factual determination. Cool. Yeah, the fact it happened once sometime, right? I mean, okay. And the Supreme Court commented the Court of Appeals should not rely on a visible fiction. It should have viewed the facts in the light of the videotape. Yeah, the fact that we have a tape that directly says exactly the opposite might be something that might be a little bit more on point. I don't think we quite have anything like that in this habeas relief, but I do appreciate your enthusiasm. Oh, Lord. The record is equally insufficient regarding requirement the trial judge consider alternatives to mistrial. First Circuit law could hardly be clearer that where there's a viable alternative to mistrial and the trial judge adequately fails to explore it, a finding a manifest necessity cannot stand. That sounds like a mechanical rule. That sounds like a mechanical rule, right? It says, oh, if there is viable and they fail to explore it, therefore manifest necessity cannot stand. That sounds suspiciously like a mechanical rule though, and there isn't mechanical rules. So that is just the particular that's just the particular but-in conclusion as it relates to that particular case, right? It's just like given everything, it's like, okay, now given that, here we are, right? That is not, no, but I appreciate your enthusiasm. It is relevant. It is important. It may be incredibly persuasive to the district court, but I don't think I'd go so far as to say that's controlling. Because if it were controlling, that would mean there's a mechanical rule, and we know there's not, so there can't be. The key here is that alternatives considered must relate to the prospect of mistrial. Fair enough. So when the court is considering alternatives to what? So mistrial must be somewhere in that equation if we're considering mistrials to it, right? It must be somewhere in the zeitgeist of the thing. Fair. The test is not whether the judge had considered that she had potential problems on her hand, but whether they accorded careful considerations to defense interest in having trial concluding in a single proceeding. Accordingly, respondents' reliance on the trial court consideration in response to first and second jury notes of the Tui-Rodriguez instruction is insufficient as a matter of law. I appreciate that, and I think that's probably true. The judge's consideration of alternatives to mistrial is an element that is not particularly helpful to her or the judge, right? And so, as we sort of discussed before in our prior discussion, Karen Reed's ability to find manifest necessity is probably on balance something that leans in her favor. So if it comes down to whether or not there's manifest necessity, there is certainly language in the First Circuit law that is binding. Obviously, we're in a First Circuit decision and it's binding on the court. So there's certainly law that seems to, on balance, favor her position. So if it comes down to whether or not there was manifest necessity, then I think the answer is probably no under the relevant law. But of course, there is another element to this thing, which is consent, which I assume we're going to get to at some point. That's more of the problem. Or if you want to call it waiver instead of consent, I think that would also be fine because it amounts to the same thing, right? Did they consent or did they waive the objection? By their failure to object is a much bigger problem. So in the 30 seconds that they had and so forth and so on. So did the trial judge give sufficient consideration? Probably not under the federal law. But does it matter, or did she waive the issue? Probably so. So things still not looking good for Karen Read, but at least as to this much of the argument, this leans in her favor, so there's that. That's nice. Can I explain manifest necessity? Well, it is essentially because I suppose the easiest way to explain manifest necessity is we had to abort the court proceeding because it was impossible for us to continue. Essentially, it would be manifest necessity. It's impossible for us to continue. So the jury being impossibly deadlocked would be such an example, right? If the jury is impossibly deadlocked, there's nothing for the court left to do. The jury is the finding of fact, and so there's manifest necessity because it's impossible for us to continue in the face of a jury that can't make a decision. So that would be an example. And you could look to other examples beyond that, but that would be an example and the one obviously most pertinent to our situation. So hopefully that explains it a little bit. If I was the judge to decide this, what would my verdict be and reasons for judgment? Well, I'm kind of explaining that as I go, right? That's sort of what I'm doing. I'm sort of analyzing and trying to explain how the law applies or doesn't apply at every sort of element. So hopefully I'm showing my reasoning. I'm showing what my decision would be as I sort of work through it and show you what I'm thinking at every step. So I'm getting there, or I'm hopefully explaining it as we go. Are they moving to dismiss? Yes, but that's a separate proceeding in state proceedings. We're not talking about the motion to dismiss right now. Later today, we'll do a response on the motion to dismiss. Right now, we're in a habeas posture to foreclose the prosecution from continuing. So different procedure, different court, different rules, so forth and so on. All right. Anyways, in response to the first and second note, on both occasions, the trial court asked counsel's view on a single legal issue, whether there had been due and thorough deliberations sufficient to support the giving of the deadlock instruction under the state law. But there's nothing in the record to indicate the judge was considering mistrial at that time. Fair. Under binding First Circuit law, the trial judge's consideration of a distinct legal issue, whether state law permits the two-way Rodriguez instruction, did not constitute required consideration of alternatives to mistrial. I agree. It's a different legal issue. Should I give the deadlock instruction and should I declare a mistrial are related but not the same. They are distinct enough. I agree. As the foregoing authorities make clear, the sufficiency of the trial court's consideration of alternatives is a question of federal, not state law. Is it though? It's not clear that it is. It's not clear that it is a question of federal law as opposed to a question of fact. But okay, sell me that this is a question of federal law. In a habeas case, state law, of course, informs alternatives available to the court, but neither the trial court nor the Supreme Judicial Court held that state law precluded inquiry into the existence of any partial verdicts on separately charged counts. Yeah, I mean, true as far enough as it goes. Yeah. The rule gives judge discretion to require a jury to return a verdict on charges which they've unanimously agreed before declaring a mistrial. True. Indeed, they could not have reached any conclusion because it would be contrary to both applicable rule and binding Supreme Court judicial precedent. The judge may declare a mistrial on any charges upon which the jury cannot agree, provided, however, the judge may require a jury to return verdicts on those charges which the jury can agree. Where a complaint or indictment in mobile counts charges mobile crimes, a general verdict could be returned as to one count despite deadlock on others. It is permissible. We know that. Accordingly, inquiry regarding partial verdicts was an available alternative. Importantly, the court need not hold the trial judge was required to pursue that alternative. Well, no, because it's optional. That they can't go that far. Rather, it's the trial court's failure to even consider the alternative that precludes a finding of manifest necessity. I'm not sure that I agree with that, because the state level rule can't determine what manifest necessity is as a matter of federal law, because that doesn't make any sense, right? Obviously, what manifest necessity means, or for that matter, what the due process clause means, or what the double jeopardy clause means, is a matter of federal law, right? So whatever manifest necessity means is a matter of federal law, at least as far as, the double jeopardy clause is concerned, it does. Obviously, state level law can have its own manifest necessity, but when we're switching from state level manifest necessity to the federal manifest necessity, because we're talking about double jeopardy, we have to apply the federal law. Okay, well, it's obviously the case that the state level rule can't control that. The state has no power to control the federal law, because that'd be really dumb, right? So this state level rule that says, well, here's an option, I don't think that you can say that failure to do that therefore makes manifest necessity under federal law. I don't think that quite makes sense, because you're saying, well, the failure to do something the state permits therefore is dispositive as a matter of the federal law. And I'm not sure that quite makes sense. So the state, something she could have considered, that's true. But the Supreme Judicial Court of Massachusetts said that they gave sufficient consideration with the options that were presented. Even though the rule permits it and it was never explicitly discussed, she gave sufficient consideration to other alternatives. And the federal court might be stuck to that. So, yeah, I don't think that quite works, but it's an interesting idea. It's not an invalid idea. It's not irrelevant, but I don't think you can quite get there. But it's interesting. There was a crazy Oval Office video today. Well, the Oval Office does whatever they're going to do. They're fun. All right. And we might respond to that at a later time, one step at a time. Let's deal with this issue on this legal issue, and then we can deal with politics in a separate stream. The Commonwealth has not established its heavy burden of establishing manifest necessity based on the existence of genuine deadlock. Ms. Reed maintains the foregoing failure to consult counsel or consider alternatives alone precludes finding a manifest necessity, and in these circumstances, no deference is due to the trial court's declaration of mistrial. As the Supreme Court has made clear, if the record reveals the trial court has failed to exercise sound discretion exercised of them, the reasons for deference disappears. Fair? Fair? The judge may declare a mistrial under any charges which the jury cannot agree, provide, however, the judge may require a verdict where they are. Okay, we read that part. Okay. At the very least, the trial court's discretion, assuming arguendo any difference is due, cannot be standardless as respondent suggests. Okay. Rather, as the First Circuit has repeatedly held, the court's exercise of discretion must be cabined by factors designed to ensure careful consideration of valued right the defendants have to their guilt or innocence. Fair. As respondent now acknowledges for the first time, the Commonwealth as a party seeking a second trial unequivocally bears the burden to establish the requisite careful consideration has occurred. Yes, I mean, it's on the government to prove manifest necessity. That's true. I mean, that's undeniable, because they're the ones that want to do the retrial, and so it's obviously on them to prove it. I mean, no doubt. Notwithstanding the clear binding precedent on the issue and Ms. Reed raising it repeatedly, neither the trial court, the Supreme Judicial Court, nor the Commonwealth even mentioned the appropriate allocation of this burden in state court proceedings. I don't know what that sentence means. Instead, the Supreme Judicial Court read ambiguous aspects of the record in favor of the Commonwealth and against Ms. Reed. That isn't necessarily improper, because whether or not they establish their burden, right? It's like, yeah, I mean, the record isn't necessarily always super duper clear, and they're going to try to figure out with it, especially if you're on an abusive discretion analysis. If you're on abusive discretion analysis, that's pretty typical. The courts are going to typically go out of their way to try to find a reason, even if it's not stated on the record. They're going to try, and even if the court stated a reason on the record, they'll try to find other reasons if that reason doesn't work. So even if the court said, here's my reason for doing it, and the court's like, that doesn't work, the Court of Appeals is typically going to say, okay, that reason didn't work. Can we find our own exciting reasons that this would be permissible? Is there any reason that that would be okay? The trial judge didn't say or didn't acknowledge. And if they can find one, they're going to say the abuse of discretion didn't happen. So, yeah, I mean, the Court of Appeals, or the Supreme Judicial Court, as the case may be, was reviewing the record and filling in the gaps to try to figure out whether or not the judge abused discretion. But that's typical. That's typical in an abuse of discretion analysis. So, as to whether or not the trial judge abused its burden or abused its discretion, yeah. Thank you, by the way, for the 500 of you who are currently tuning in. I hope you're learning something. I hope you're having a lot of fun in this legal education video. This is good stuff legally. We're doing deep dive law today. So I hope you're having a great time. And if you wouldn't mind, I would appreciate it if you'd hit the like button. It seems to really help with the algorithm. They seem to really like the like button with the live streams. So I'd really appreciate that. And if you wouldn't mind hitting subscribe if you hadn't, that'd be nice. And also you could hit the join button for 99 cents, throw a buck in the tin. Give me a dollar. Give me a dollar. $1. What can a dollar buy? Not much, but it can buy a little bit of my love. Lol. All right, let's press on. Let's press on for this. All right. Let's see. Where were we? Respondent. Okay. Respondent's contention that the deadlock jury is a type of manifest necessity sufficient to meet the Commonwealth's burden, of course, simply begs the question as to whether a deadlock has been established. I don't think that's the issue. I don't think that's the question. The key to the principle is the jury must be genuinely deadlocked. The reversal of the burden of issue constitutes clear error. I don't think that's what the Supreme Court of Judicial Court was doing. I don't think they were reversing the burden. I don't think that's true. I think they were trying to decide whether the judge abused his discretion in, declaring the mistrial, because it's an abuse of discretion analysis. So I don't think they reversed the burden. I don't think that's what happened. But, okay. Notwithstanding its provision of the Tui Rodriguez charge earlier in the day, at the crucial point after the jury sent its final note, the trial court took no steps to clarify the scope of the impasse. While they didn't take any explicit steps, that's certainly true. They didn't do anything in particular. That's true. In fact, while the prior instruction encouraged the jury to reach a verdict, at no time did the trial judge do anything at all to confirm whether the jury had reached an impasse on all counts as opposed to merely some set of the counts. Yeah, but that only makes sense if the judge had to do it and they don't. They don't have to inquire about partial verdicts. We've sort of discussed this. Yeah. All right. The court should reject respondent's alternative argument that Ms. Reed consented. All right. So let's discuss the manifest necessity. So on balance, I think Karen Reed has better odds than not. So if we were merely on the issue of manifest necessity, I think that Karen Reed's odds are better than not. There is the 3-factor test, which is not dispositive, as we've discussed, but 2, if not 3 of the factors lean in Karen Reed's direction. And there is certainly no explicit consideration, or really even implicit consideration, on the record of any particular alternatives to the mistrial. right? So there's nothing explicit there, or even really implicit there, to be quite honest. So, if I'm trying to decide whether or not she gave sufficient consideration to the alternatives, assuming I'm not bound to the Supreme Judicial Court's determination of that, assuming I'm not bound to that, then as a federal judge, I'd be like, yeah, probably not so much. So if the issue was manifest necessity, I'm not sure I find it. I'm not sure I find manifest necessity. So Karen Reed would be likely to win, in my opinion, if that were the thing. Unfortunately, we have another thing, which is the issue of consent, or if you prefer to call it, waiver. Right? General principle of law. General principle of law. If you have an objection, you have to raise it. If you don't use it, you lose it. If you don't have it, if you don't use it, you lose it. So if you can object and you don't, usually it is gone. And so we have to discuss that issue. The court should reject respondent's alternative contention, which the Supreme Court Judicial Court did not rule upon, that it constituted consent. Yeah, the Supreme Judicial Court didn't reach that issue because they found manifest necessity, so consent was irrelevant. So assuming the Judicial Supreme, and incidentally, by the way, there's nothing that precludes the court from doing it in either order, right? And typically courts will try to find the easiest ground they can to rule on. So like if there's multiple different ways to get to the end, they're going to find the one that works for them and call it a day. So it's not necessarily even the case that the judge in the federal case necessarily even has to talk about manifest necessity, right? If they think the issue of consent is the issue that determines Miss Reed loses, then they don't even have to talk about manifest necessity because it doesn't matter, right? So you could hypothetically have an opinion that only talks about the issue of consent because that's the issue that allows them to dispose of the case. And they're like, well, we don't really care about that manifest necessity because it doesn't matter. So you could get that from the district court for sure. All right, the sole authority relied upon to support the argument, United States versus DiPietro, is readily distinguishable. DiPietro did not involve jury deadlock. Instead, the court declared a mistrial after the government asserted the guilty pleas and conviction of other alleged participants in the defendant's criminal conduct constitute evidence that all the elements of the accusation against the defendant had been proved, thus using their convictions for purposes other than credibility. After a research from lunch, court summoned counsel and court reporter and took notes while the reporter read back the government's rebuttal argument, after which attorneys withdrew with no further comment. Yeah, that's a problem, right? So, failure to object, right? It's like, oh, they're using this evidence which can only be used for credibility, and now they're using it for things other than credibility, right? It's like, oh, you can't do that. You can't do that. And defense is over here like cricket noises from the defense table. That's not really positive. DiPietro is an opposite for a number of reasons. First, the error occurred several hours before the declaration of mistrial, and defense counsel was arguably on inquiry notice when the court summoned the attorney for conference and review of the erroneous argument. So, yeah, fair enough. It's like not only did you have an opportunity to object in the moment, presumably, which would have been enough, but the judge even went one step further, right? The judge even went one step further. It's like, okay, I have some concerns about this. I'd like to look into this issue a little bit more, right? So let alone you had the opportunity to object in the moment, which might be enough. The judge apparently went a little bit out of their way to say, hey, have some concerns here. And the defense team's like, cricket noises. It's like, well, what more do you want, man? They gave you the out, man. Damn, right? Here, by contrast, the trial judge called in the jury immediately after informing counsel the jury was an impasse and before it even disclosed the contents of the note. Yeah, but they said she didn't read the note out loud. That's true. But she said, I'm paraphrasing, she basically said, like, I've received a jury note that they're in an impasse, so I'm declaring a mistrial. So she didn't read the substance of the note, but you knew what the punchline was, right? You knew what the punchline of the note was. So I think you knew enough things to object. It's like at that point. It's not, I'm not sure knowing if the content of the note really gave you anything more than you had at the start. So it's not like, oh, we didn't know the note and the note somehow was somehow the basis for which we would have had the impetus, and that was a new thing. I don't buy it. I don't buy it. 24 hours in said, could lack of objection be used as ineffective a counsel appeal if Karen Reed is found guilty after show trial number 2? Ineffective assistance of counsel is really hard, and it's very hard. So could she try? Yes. Will it work? Almost certainly not. Almost certainly not. Because I mean, we'll never know for sure. We'll never know for sure, of course, because we can't run the counterfactual. But if the judge had said, hey, do you want partial verdicts? I don't think the defense would have said yes. And incidentally, by the way, in the new trial, I don't think the defense is going to ask for it either, which will be very telling when that happens, right? When they're discussing the new jury instructions, I would suspect when they're discussing the new jury instructions, the judge is going to quite explicitly ask the defendant, hey, do you want partial verdicts? And I don't think the defense is going to ask for it. You know, I don't think they're going to ask for it. And I don't think they would have asked for it then. You know, defendants' lawyers have gone to court on more than a few occasions to be like, you shouldn't have asked for partial verdicts. It was too prejudicial. So I don't think you can raise an ineffective assistance of counsel defense, because you would have had to show, you'd have to basically show that no reasonable defense attorney in that moment would have not asked for partial verdicts. And I don't think you can show it. I don't think you can show no reasonable defense attorney wouldn't have asked. They're insistent now because they know the answer now, but that's cheating. That's cheating. You can't go on what you know now. You have to go on what you know then. You can only make decisions based on what you know in the moment, obviously. So you can't use what you know now. That's cheating. All right. Here, by contrast, the trial judge called on the jury immediately after informing counsel the jury was at an impasse and before it even disclosed the contents of the note. The jury arrived a mere 30 seconds later. Counsel cannot reasonably be expected to have anticipated the sua sponte mistrial declaration. Really? Really? You couldn't have seen that one coming? Really? Given the court's established practice of reviewing jury notes with them and providing an opportunity to respond, a continuing predictable prior practice the counsel had every reason to believe would not be varied from this pivotal moment. Yeah, but they gave the deadlock instruction. This note is not like the other notes, man. And 40 years of precedent guaranteeing them a full opportunity to be heard before mistrial was declared. Yeah, but as to the precedent, that is a matter of state level law. You can't go to federal court on that one. You can't go to federal court on that one. So they're like, hey, 40 years of the Supreme Judicial Court precedent says we have an opportunity to be heard. The Supreme Judicial Court of Massachusetts just told you they don't care. Just now. That's it. That's the end of that one, right? I mean, the Supreme Judicial Court said, you know, that was okay. So I don't know whether or not that overruled 40 years of precedent or not, but either way, that's it, man. That's the law of the case at a bare minimum with respect to state level law, man. Damn. All right, let's press on. Second, while the DiPietro court found ample opportunity to object when the mistrial decision was declared, such an opportunity to object in the presence of the jury is not sufficient where, as here, a mistrial is declared for a jury deadlock. Why not? As one authority heavily relied upon by DiPietro observed, when defense counsel objects in the jury presence after a mistrial declaration due to jury deadlock, he endures the risk the jury will hold him responsible for compelling them to continue deliberations contrary to both the opinion of the judge and jury. But you did have the 30 seconds, though. And if what you wanted was not, I want you to continue deliberating, but I want to know whether or not you've already reached a decision. That's what I want to know. I don't know why the jury would hold that against you. It doesn't quite make sense. Finally, while the DiPietro court noted counsel's failure to object after the jury was dismissed in combination with other prior opportunities to object, such an after-the-fact opportunity standing alone does not rise to the level of consent. And then they cite, by comparison, a case which notes the district court only addressed counsel after reading and confirming a verdict in open court and asking if there was anything else before discharging a jury. So, I mean, I don't know the finer points of that case, obviously, and I'm not going to dig into it right now because I can't be bothered to weed chase forever. But, you know, sure, under some circumstances, maybe. Under some circumstance, maybe, but, you know. And it's also a compare, which suggests to me the CF tag. The CF means compare. So the compare means, it suggests to me that it's not quite as parallel as it means. Normally, the CF notation means... it's a little bit more of an orbiter case, right? It's like it's interesting, but it's more of an orbiter case, right? It's not super close. Moreover, the post hoc discussion in DiPietro, unlike that issue here, specifically related to the explanation of counsel for mistrial, substantially increasing the likelihood that counsel would have raised any objection they had regarding the issue. Okay. Finally, respondent's characterization of DiPietro is contrary to a string of First Circuit precedent relied above. If counsel's mere failure to object to sui sponte declaration of mistrial, upon which counsel was not asked to comment, amount to consent, then defendants in Brady, Ramirez, and the other case would have been found to consent in their mistrials. Yeah, but those cases are not quite factually the same. Right? Those cases are not quite the same. So, like, yeah, does the failure, is it possible to get over the failure to object? Yeah, it's possible. Right? It's possible. If the judge shuts you down, if the judge won't let you talk, if the judge just storms off the bench without giving an opportunity at all, right? Is it possible to get over failure to object? Sometimes. Sometimes it's possible. But, you know, it's not usually. And I'm not sure here. So, yeah, there's, you know, the rule, did you know law is filled with asterisks? Did you know law was filled with asterisks? Did you know sometimes, even if they fail to object, sometimes it's okay? Did you know the law was filled with asterisks? I hope you knew the law was filled with asterisks. If not, yeah, it's filled with asterisks. Asterisks everywhere, man. Asterisks for days. Clearly, that's not the law in the First Circuit. All right. The jury's unanimous conclusion following the trial that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. Okay. As noted in Ms. Reed's opening memorandum, whether an acquittal has occurred for the purpose of double jeopardy is a question of federal, not state law. It would have to be. Of course. I mean, we're talking about the Fifth Amendment. The Fifth Amendment, last time I checked, is in fact a federal law. The supreme law, one might even say. Yeah. So, I mean, obviously, whether or not double jeopardy, I mean, yeah, that's insofar as we're talking about the Fifth Amendment, sure, it's a federal question. I'm quite clear on that point, no problem. This in itself is sufficient to reject the argument. The Supreme Judicial Court's instruction on what constitutes a verdict is definitive and binding. Maybe. If you have federal law that says to the contrary, I suppose possible. So, you know, yeah, I suppose that's possible. While operation of state law may inform whether a jury reached such a conclusion, by defining what a jury is required to find, the court may not defer to state procedural requirements regarding the form of any such finding may take. Slightly overstated. I mean, it is ultimately a question of law, so strictly speaking, true, but I don't know that I'd go quite so far as to say that, you know, what the state has to say about the form is completely, like, irrelevant. I mean, obviously, isn't controlling. It's not binding on the federal law, but, you know, is, you know, something. In McLareth, for example, the Supreme Court of Georgia had vacated a verdict finding the defendant not guilty by reason of insanity under the state's repugnancy doctrine. Yeah, I remember this case. That was really dumb. Yeah. That was really dumb. So in that case in Georgia, what happened is the jury came out with mutually inconsistent verdicts. The jury came out with mutually inconsistent verdicts. They came out with two verdicts that cannot be squared with each other. They can't both exist at the same time. Although it wasn't the case on point, the example I always use to explain this would be a felony murder conviction in which the jury also acquits of the underlying felony, right? A felony murder requires there to be a death in the commission of a felony. That's what felony murder is. So how do you convict a felony murder while also acquitting of the underlying felony? If you're asking, that's a good question. You're right. It's a very good question. How do you do both? Now, the U.S. Supreme Court has made clear on a few occasions, incidentally, because they've been asked about this at least 3 or 4 different ways, to be asked, like, are you really sure? And yeah, the Supreme Court's really sure. So they've been asked like 3 or 4 times, hey, if there's a verdict, like they're guilty of the felony murder, but acquittal of the underlying felony, like, is that okay? And the Supreme Court has said 3 or 4 times, yes, that's okay. Justice Scalia wrote the majority opinion, I believe, on that one, basically saying, yeah, we don't know what was really going on. Maybe the jury decided to show mercy. Maybe they decided maybe they decided to compromise. Like, we don't know where the error is, basically. We don't know where the error is. Was the error in failure to convict, or was in the error of the conviction? Like, we don't know where the error is. So mutually inconsistent verdicts are not a problem. Incidentally, by the way, as a matter of federal law, mutually inconsistent pleading isn't a problem. So you can, as a lawyer, although it's not necessarily advisable, but strictly speaking, it is allowed. I can go into court on a petition and I can argue out of both sides of my mouth at the same time. I can argue this is true and also argue it's not true at the exact same time. How fun. How fun, right? So I can do mutually inconsistent pleadings. I can do mutually inconsistent verdicts. I'm allowed to be illogical. It's exciting. That's fun. Now, Georgia had a problem. It's like, we have mutually inconsistent verdicts. We have a not guilty and a guilty, and both these verdicts can't make sense in the same universe. It's like, okay. So Georgia had basically one of 2 options at this point. Georgia had one of 2 options. They could have said, okay, we're going to follow the federal rule and say, we don't care. We don't care. It's totally fine. The inconsistent verdicts are fine. Everything is fine. Or they could have said, okay, as a matter of our own state law, this is completely intolerable. We are not going to tolerate this. Inconsistent verdicts don't work for us. We don't know what the feds are talking about. We don't like inconsistent verdicts. So what we're going to do is we're going to change the guilty to a not guilty, right? They could have done that. But what they decided is a third exciting option. They found a third exciting option. They said, what we're going to do is throw out the not guilty verdict. What we're going to do is say the guilty verdict stands, but the not guilty verdict is now void. It's void. The jury reached the decision of not guilty, but what we're going to say is that not guilty verdict no longer counts. Yeah, the U.S. Supreme Court had a problem with that one. The U.S. Supreme Court had a problem with that. They're like, no, you can't do that. Bad, right? The jury said not guilty. That's not guilty. And incidentally, the trial judge accepted the verdict, right? The trial judge accepted the verdict. The trial judge said, okay, I'm going to accept both these verdicts. It was the Supreme Court of Georgia that's like, nope. And the Supreme Court's like, yeah, that's not an option. You can't do that. You can't do that. That is not a valid choice. Yeah, that one was fun. Yeah, so anyways, in McClaren, the Supreme Court of Georgia had vacated verdict, finding the defendant not guilty. They threw out the not guilty based on the repugnancy doctrine. That doesn't make sense. These verdicts are repugnant with each other, which the state court rendered the not guilty verdict a nullity that should not have been accepted. Oh, Lord. The Supreme Court of the United States reversed, reaffirming that because double jeopardy focuses on substance over labels, a state's characterization of its ruling is not binding. In other words, it's not dispositive of whether the fact finder incanted the word acquit. Instead, acquittal has occurred if the fact finder acted on its view, the prosecution's failed to prove its case. Yeah, that one was fun, man. That one was a good time, man. Holy shit. That one was a fun time. Oh, what a case. What a case. Respondent maintains the form must control over substance in the context of jury acquittal, even though it conceitedly does not for jury acquittals. Okay, this contention is inconsistent with Clariff itself, which refused to elevate form over substance in the context of acquittal, as well as the Supreme Court's clear instruction. The double jeopardy clause prohibits re-examination of court-decreed acquittal to the same extent it prohibits re-examination of an acquittal by jury verdict. So if it were a bench trial or a directed verdict and the judge said not guilty, that also is final, amazingly enough. You can't appeal a not guilty verdict in the United States. I know this is really hard apparently to understand by this government. They're like, in Canada you can. In Canada you can if there's a legal error, and we're all thrilled that Canada apparently allows you to appeal a not guilty verdict if you find a legal error. That's super duper interesting and all, but not so much in the United States. So it doesn't really matter if the jury found it. It doesn't really matter if it was a bench trial and the judge found it. It doesn't really matter if it was a directed verdict at the end of the case. A not guilty, you can't appeal the not guilty verdict. They keep trying, though, for some reason. They keep trying to appeal the not guilty verdicts like they did in the Georgia case. Holy shit. That's literally what they were doing. They were literally appealing a not guilty verdict. That's exciting. You can't do that. However, it may be in England, in this country, a verdict of acquittal, although not followed by any judgment, is a bar to prosecution. Respondents also ignore Supreme Court case law finding jury acquittals implied by conviction of a lesser offense. Conviction of a lesser offense. Well, I guess maybe. Yeah, I suppose. I mean, either way, it might imply it, because if you acquit of the lesser included, then they're obviously acquitting of the greater. That makes sense, because the lesser included is included in the greater. If they only find guilty of the lesser, they obviously failed to find the element that changed it to the greater, right? A lesser included by its nature simply is lacking an element the greater has. So the lesser included might have 4 elements. The greater has 5. If I've convicted you of the lesser, but I've acquitted you of the greater, then implicitly what I'm doing, if we're going to apply logic, implicitly what I'm doing is I'm saying I didn't find the 5th element, which is, of course, is a finding of fact by the jury. Juries find facts. That's what they do. And you can't challenge that in a new trial. You can't challenge the jury's findings. You can't challenge that unless, of course, you're challenging it in favor of the defendant, right? And then you're back to a conviction that was batshit insane. So you can challenge it one way, but not the other. You can challenge it one way, but not the other, because of the double jeopardy clause. So, yeah. We believe this case can be, and then they cite another case, Green versus United States. We believe this case can be treated no differently for the purposes of former jeopardy than if the jury had returned a verdict, which expressly read, we find the defendant not guilty of murder in the first degree, but guilty of murder in the second degree. I mean, fair, right? I mean, that makes sense. Apparently that jury found not, or I suppose probably hung, to be quite honest. Apparently the jury hung on murder in the first degree, but found guilty of murder in the second degree. And it's like, well, okay. That's the end of that game. Thanks for playing. In one such implied acquittal case, the Sixth Circuit relied on the very same language from the Supreme Court's Martin and Lemon opinion that respondents criticized petitioners for citing here. We must determine whether the ruling of the judge or jury, whatever its label, actually reflected a resolution, correct or not, or some of all the factual elements of the charge. As Ms. Reed's initial memorandum noted and the respondent fails to address, in the rare situation presented here where a jury reflects a final decision the defendant is not guilty, but failed to accurately announce the verdict, federal courts have acknowledged substantive acquittal notwithstanding lack of form. I mean, it's not like the worst idea, and I don't really see this idea working. And if this idea works, it'll be pretty cool, though, to be quite interesting, because that would be an interesting development of law. Right? That'd be an interesting development of law if this works. And we did read that, what was it, 10th Circuit case, I'm pretty sure, where the jury actually came back and was like, we swapped the verdicts, though. Which, like, okay, yeah, we found them guilty of this one conspiracy charge and found them not guilty of this other conspiracy charge, but we meant it the other way around. Lord have mercy. And the trial judge brought them back in and confirmed all that, and then basically reversed the verdicts. And he said that's not fair because the jury found not guilty. You can't convict me. 10th Circuit Court of Appeals upheld that one, though. They said, well, look, this wasn't a change of the jury's findings. It was simply an inaccurate recording of their findings because the jury apparently checked the wrong box. But we're not trying to change what the jury found. You know, the jury actually did find this in reality. They just were a little confused by the paperwork. So we're going to just correct it. And that isn't double jeopardy because they're just correcting it to what was real, even though that meant finding you guilty or previously not guilty because we're just correcting the record. It's like, okay, maybe that's okay. So there is that one case out of the 10th Circuit that sort of says that. And if it's okay to do it for guilty, then maybe it's okay to do it for not guilty, right? So, you know, not a completely invalid idea. I don't know that it works here because it isn't that they didn't check the form. It's that, you know, that's what they thought because they thought because the judge they thought required complete verdicts. See, in the 10th Circuit case, the jury did return verdicts. They returned verdicts, presumably in all the charges, and they were then read and, you know, entered into the record and all the rest of it. And now we're simply correcting what the jury did. And I don't know whether that judge allowed partial verdicts or not. Whatever. And so they did whatever they did. But here that only works really if the judge is required to do complete verdicts, right? And that's the thing, right? It only constitutes acquittal. Like even in theory, it only constitutes an acquittal if the judge is required to ask. And as a matter of federal law, if the judge is required to ask, and then with that is then required to enter that verdict. And I don't know that law exists. So if they're not required to ask for partial verdicts or even required to accept partial verdicts, you know, then I don't think this works. But it's an interesting idea. Bluford versus Arkansas, as previously explained, was decided based on lack of finality, not form. Yeah, I mean, to some degree. Respondent admits in much, but false petitioner for making a flawed assumption. The purported jury statements and issue here reflect the jury's position at the end of deliberations. The question is, does it matter, right? If we take it as given. Right? And I don't know how you can say that the jury having said not guilty on 1 and 3, but being undecided as to 2. I don't know how you can say that constitutes an acquittal unless the judge is required to accept partial verdicts, because it is by its definition a partial verdict. That is a partial verdict, right? The jury says not guilty on 1, not guilty on 3, we don't know on 2. That is by definition a partial verdict. It's not complete, it's partial, right? So that can only constitute an acquittal if the judge is required to accept that partial verdict. And I don't know of any case that says that. So I don't, in the absence of a case, what do you want from me? All right. As an initial matter, the affidavits and issues were all executed post-trial. None suggest the agreement to acquit Ms. Reed was tentative or changed. In fact, I don't need to go through that. We can skip that. Alternatively, the defense is entitled to post-jury inquiry in determining whether evidence supports jury representations having acquitted. Only if it matters, right? Only if it matters. There's no reason to do this unless the answer matters, which is the whole thing, right? That's the whole game at this point is what is the legal posture here? Ms. Reed has clearly satisfied the burden of production to establish entitlement to further inquiry. Not really, no. You haven't established the burden of production because you haven't established it matters as a matter of law, right? It's like I provide sufficient evidence to ask, not if it doesn't matter as a matter of law, right? I mean, I can have lots of irrelevant evidence, but if it's not relevant, then, it doesn't matter. Contrary to respondent's characterization, there's no indication in the affidavit that it was preliminary or result of mere straw poll. There is certainly no indication in the notes of that, and that's fair enough as far as it goes. Okay. While respondents now suggest doubt regarding the veracity of the statements, referring to no fewer times than 16 to the purported statements or juror statements, I mean, They are at the moment purported, because we don't know for sure, but that's fair. The fact remains that it presents no contrary evidence since July 8th filing of the motion to dismiss. In fact, to the contrary, the Commonwealth was contacted by an individual who identifies themselves as juror and seat number, saying they could confirm unanimous charges on 1 and 3 as not guilty. In any event, both state and courts have assumed the truth of the statements, which on their face entitled to further inquiry. I have no problem with that issue. Like the statements themselves are sufficiently clear that, assuming that, all the rest of it, then yeah, fine. But the legal posture is the problem, not the factual posture. Legal posture is the problem at the moment. Ultimately, there's only one way to determine whether the jury in this case, in fact, was unable to reach a verdict, or by contrast, to reach a partial verdict, through voir dire by this court or the trial court. That would almost certainly be done by the trial court. It would almost certainly be done. I can't. That would be weird if the federal court did that. That'd be really weird. But okay. Respondent notably did not dispute the stunning implications of the Supreme Judicial Court decision. No defendant claiming a jury acquitted her but failed to announce the verdict would be entitled to further inquiry, no matter how clear or well supported their claim. I mean, basically, yes, that's true. That's essentially true, but that's kind of where we're at the moment. Even if all 12 jurors had submitted an affidavit saying unanimously and finally agreed to acquit, their failure to announce would be taken as precedent precedence over defendants' fundamental rights to double jeopardy. Well, that's a pretty argumentative way to put it, but yeah, basically, like, even if we had affidavits from all 12 saying exactly, yeah, we were all not guilty, right? We're still in the legal posture. Like, what does that mean? What does that mean as a matter of law? Juries find facts, courts find law. So the jury's saying, okay, we're all not guilty. What does that mean as a matter of law? What does that mean at this point, right? That's the thing. Calling jurors into court and asking whether they reach a final unanimous verdict to acquit Ms. Reed would be accompanied by the same solemnity, if not more, than generally attaches. The answer to the question would, of course, necessarily, yeah, you say that, you assume that. Yeah, that's one hell of an assumption, by the way. You assume it would dispel the concern. Yeah, you're working under the assumption that all 12 members are going to come in and say what you want them to say. What if they don't say it, though, right? That's a whole other set of problems. What do we do then? What if one member says no and the other 11 say yes? What do we do then, right? Holy shit. So you assume it's going to dispel it, but you're kind of assuming what's going to happen. But I digress. Would dispel concerns that any discussion was merely preliminary as opposed to final. It would also confirm what defense affidavits already expressly state, that all the jurors, not some, agreed agreed is not guilty. You hope it confirms that, man. You hope it confirms that. Holy shit, man, right? Those statements were widely publicized more than 7 months ago and not been contradicted. I take exception to that argument. I take umbrage to that argument. As has been more than well noted in many trials, a juror is not under any obligation to talk to anyone if they don't want to. The fact that the other 7 juror members are silent, I really don't think can be read to imply anything. And I take exception that it can be read to imply anything as to what those other 7 members would say or do think. It's like, yeah, surely if any of the 7 disagreed, they'd make themselves known. Like, first of all, they don't have to. Second of all, I can think of reasons they might not want to, right? If there was a juror, just take the hypothetical, right? Just suppose that one of the jurors, at least one of the jurors, is like, no, that's not true. It's like, can you think of any reasons they might not necessarily want to announce themselves? I can think of reasons they might not necessarily be super thrilled about announcing themselves. So I'm not really sure you can infer anything by silence. That argument's dumb and I don't like it. Respondent's suggestion the remaining jurors may have let the 5 go uncorrected for fear of drawing further attention to themselves might explain why any 1 or 2 jurors have failed to come forward, but defense respectfully submit it cannot convincingly explain the silence of all 7. Well, that I don't even know what that means, even hypothetically. Like, that assumes that all 7 disagree, which isn't even true. Like, maybe there's no reason for 6 of the 7 to come forward, right? Maybe 6 of the 7 would agree. We're unanimous. Maybe it's only the 7th who would disagree. Who can say, right? So, and maybe they don't want. Maybe the others 6 don't want to come forward because they feel like there's no reason to, and the 7th doesn't want to come forward because they're afraid of the world and stuff, because it's a pretty publicized trial. So that doesn't quite flow. In any event, it's a matter readily discernible for a request for voir dire, which could be conducted anonymously. You would think it would, hopefully. Respondents focus on a few purported inconsistencies among the statements, overlooks the overarching consistency. I will agree the statements that are presented are consistent. That is not the problem. That is not the problem. The jury unanimously agreed misread of 2 of the 3 counts, including the account of a second-degree murder, which of course is the most important thing because it's the most severe charge. The inconsistencies cited simply pale in comparison are irrelevant. I don't know that I go so far as to say irrelevant, but I would say that yes, they're consistent enough for the inquiry, assuming it matters. I would agree with that. Asking the jury whether it reached a verdict does not infringe on deliberations. Fair enough. We're not asking you what you thought. We simply are asking you what your end conclusion is, right? We're not asking why you thought that. We're not asking what you thought about deliberations. We're not asking what you talked about. Like, literally just tell us, did you think not guilty? And that is, I agree that is not going towards their deliberations. It's going towards their verdict, which is not the same thing. We ask juries their verdict all the time. We do it in open court, right? So asking juries their verdicts is not the same thing as asking about their deliberations. Yeah. Let's see. But respondent fails to articulate how such peripheral issues could change the inevitable constitutional effect of a statement by all 12 jurors. You hope that they reached a final unanimous conclusion that Miss Reed is not guilty of murder. Even assuming arguendo, and contrary to the petitioner's contention, the request of voir dire would violate federal rules of evidence, which I don't think it does, because yes, we're not allowed to look into the jury's deliberations, but I don't think this is that. So I don't think that's true. I don't think it violates the federal rules of evidence either. It's a different thing. Respondent does not dispute evidentiary rules cannot extinguish their rights, which is true enough as far as it goes, of course. Evidentiary rules also have to bend to the Constitution. That is true. Miss Reed, whose absent intervention of this court will stand trial for murder beginning April 1st, self-evidently has a powerful interest in determining whether or not she was in fact acquitted of the offense, but is not the only interest at stake here. Democracies die behind closed doors. Citing Detroit free speech versus Ashcroft. What the F? Why are you citing a First Amendment case all of a sudden? What with this? What the hell, man? Why are you talking to me about the First Amendment all of a sudden? What the hell are you talking about? Holy shit. What? As the Supreme Judicial Court observed in a case cited by a respondent, an inflexible rule like that imposed excluding all jury testimony achieves stability at the expense of doing justice between the parties in a result not consistent with the ideal of a true and impartial jury. In the case that has generated enormous media attention at a time when confidence in the judiciary is of the utmost importance, the public has a strong interest in a full and fair hearing, as well as giving effect to any unanimous decision by the 12 jurors. Respectfully submitted, Martin Weinberg. Cool. All right. Yeah. Okay. So I'm sort of basically back where I still was when I was talking to Melanie. So this is different than when I was on my last stream on this channel, because on my last stream on this channel, I made a mistake because I was applying the standard at 2254, and I'm like, oh, she has no chance. But then I read it and I'm like, oh, no, wait, no, 2254 doesn't apply. It's 2241. She does have a chance. So in my last stream on this channel, I said her odds were 0. And then I read some more and I'm like, oh, no, wait, that was a mistake. I made a mistake. Her odds have improved. Her odds have gone up, and then I was on Melanie's channels and I think I said something like 1 in 5. And it's like, yeah, we're something like in that territory. Maybe it's 1 in 10, it's like whatever. It's like, there's a chance here. Like there's first of all, there's a non-zero chance that the court will abstain from hearing the case. Yes, I know there are hearings scheduled. That doesn't mean the court will hear the case, right? They might have many hearings and then decide, no, we're not going to do it, right? So there's a first of all a non-zero chance the court invokes abstention doctrine and just declines to hear the case. Now there's some First Circuit precedent that says they don't have to, but it's a non-zero chance, right? So you gotta remember, like, there's this possibility when you're sort of calculating the odds. Like, okay, there's a chance they're not going to really hear this case in the end. It's like, okay, that's true. And then, of course, deciding that they do hear the case, right? There's sort of this underlying issue about whether or not the Supreme Judicial Court saying that they had sufficiently considered alternatives to mistrial. Like, is that binding on the federal court? It's like, I don't know whether or not it is. If it is binding on the federal court, and I'd have to think about it harder, right? I have to think about it harder because it's an interesting question. Like, is that a question of fact, or is that a legal conclusion? And if it is a legal conclusion, is it one I'm free to ignore because it's de novo review, which it would be. So if it's a factual conclusion, then she doesn't even win on manifest necessity. But if it's a legal conclusion, then I can be like, okay, yeah, I can ignore it. So I'm just going to assume I'm going to assume that on balance that she wins the manifest necessity ground because it seems more likely under the case law. It seems more likely that a federal court would be inclined to view it as legal, or at least not binding in a way that, would change their analysis. The 3-factor test is as good as it's gotten. There haven't been suggested by either party any new exciting factors, right? The best the Commonwealth has is the Supreme Court saying that there are no particular benchmarks, right? There are no particular benchmarks, but the First Circuit's provided something, even if it's not dispositive. So it's like, okay, well, Karen Reed seems to be doing better on the 3 factors that are available. There haven't been any suggestions of new and exciting factors that this court should apply. So in the absence of that, the court's going to apply the 3-factor test, because why wouldn't they? And they seem to lean in favor of Karen Reed. So it seems like on balance, she wins on manifest necessity. So it all sort of boils down to the issue of consent or waiver, right? Was the 30 seconds that they, when the jury is being brought in, sufficient, or even potentially the minutes that the jury was still sitting in the back room? They've been dismissed, but they're still sitting in the back room. We can just go get them. They're right there. So, is that sufficient time? Is either the 30 seconds or the minutes while they're sitting in the back room sufficient? My best analysis says it is sufficient. Again, like the idea that it's sufficient, at least in part because there had been that Tui Rodriguez charge, right? There had been the Allen charge. There had been the Deadlock charge. And so like we were totes surprised that the judge was going to say mistrial. I can't buy it. It's like, I can't buy into that. It's like you had to know that was something that was a very strong probability at that point, right? It's like once that instruction is given. So it's like, oh, we were complete surprise. We were taken completely aback. I'm having a really tough time buying into that, right? So I don't think they were particularly surprised, notwithstanding their own protestations to the contrary. I don't buy it. And so I think the 30 seconds was sufficient legal time to object and ask for a sidebar and be like, or we have more things to discuss. And the judge could even hypothetically, of course, sent the jury back and had argument. I've seen that kind of thing before. And we've seen that before in other trials, sort of in other contexts. Like the jury's brought in and basically the counsel's like, we have some things we'd like to discuss. And like the jury's then immediately sent out of the room again. Kind of frustrating for the jury, right? But ping-ponging the jury, not exactly unheard of. So yeah, I think they're going to lose on the issue of consent/waiver. So I think her odds of winning are basically like, 1 in 5, or maybe something like 1 in 5 to 1 in 10. It's something like that, and obviously the clearest way for the judge to disagree with me is to disagree with me on the issue of waiver, right? Because if the judge disagrees with me on the issue of waiver and be like, oh no, this isn't sufficient, or 30 seconds isn't long enough, or, whatever else they, want to say, if they disagree with me on that, if they disagree with me on which way that lands, then, her odds go up dramatically. So that'd be good. That'd be good. So I think she has, and it would also help a lot, incidentally, for Karen Reed or the Commonwealth, either way, as the case may be. It would also help a lot if the DOJ decided to intervene, which to the best of my knowledge, they have not done, right? Because there's that whole federal investigation. Now, it is, of course, worthy of mention that, who is the DOJ has changed recently due to the change of administration. So we can't necessarily infer that any prior members of the DOJ, including the local U.S. attorney or their office, might necessarily have the same interest in this as the old U.S. attorney did. So the old U.S. attorneys seem to have a stronger interest in this. So it would be up to obviously whoever the new U.S. attorney is and or Maine DOJ to potentially issue a amicus brief in this issue or otherwise seek to intervene. If the DOJ or the U.S. attorney seeks to intervene, and that would improve the odds dramatically for either side, depending on which side they went on. So if either way, right, it would dramatically change the odds. So, and you would anticipate that the court would be strongly inclined to follow the DOJ either way. So if that happens, then that will change the odds. But based on where we're sitting right now, I don't know. Yeah, 1 in 10, 1 in 5, maybe. So she's got a chance, but may the odds be ever in your favor is where we're sitting on that one. So yeah. Cool. So are there any sort of questions, comments, considerations, chats, whatever you want to give me while we're wrapping this up? I'll spend the time reading the super chats and members that did come in. Susie Q has upgraded their membership to the Devil's Advocate. We do appreciate everyone who joins at that higher membership tier. We do appreciate you sending a little additional money that went my way. It's really appreciated. Thank you very much. Chopped Trials has been a member for 2 months. Chopped Trials for $4.99 says, thanks, Kurt. This is my vote to look at anti-BEV Rule 14 changes. I appreciate your commentary. We may well do that. Probably not today, because we're going to look at the motion to dismiss response in state court later today. So I'll probably take a little break and look at that a little bit later this afternoon, probably in about an hour or two. Take a look at that, and that might be fun. And we'll take a look at the changes, and I think it's very interesting that the judge apparently chaired the committee to revise the rules. That is chef's kiss interesting in my view. That is just next level gamemanship that I did not see coming. That's interesting as hell. The Broken Scout became an uncivilian. Angie Smith became an uncivilian. SJ became an uncivilian. Patty Hoffman became an uncivilian. Mudraker became an uncivilian. Lee Ren Wood for $5 said, going to watch the latest newest from the Oval Office because, oh my God, apparently was fiery. So I've heard it was fiery, and maybe we should watch that and live stream that. But either way, we're going to do it in a new stream because obviously we need to give people a chance to, to do stuff. Off topic, did I see a stay from the Supreme Court for Trump? No, I didn't see a stay from the Supreme Court for Trump. That's interesting, and that's interesting, and but not necessarily particularly surprising. A lot of these things, depending on exactly what the stay is in relation to, a lot of these things that the federal government or Trump is trying to do are very questionable under federal law. There's problems with the Administrative Procedures Act as it relates to agencies. There's problems relating to authority of various agencies to do things. For example, what is the authority of DOJ or even the OPM to fire people? Unclear. There's legal problems with a lot of what they're trying to do, legal issues at least, even if not legal problems. A lot of federal workers are protected by Title V, so you can't necessarily just fire them without due process. In some situations, in many situations you can't. Some federal employees you can. Most federal employees you can't. So there's lots of legal issues with a lot of things that they're trying to do. And it's all very interesting. I'm not really getting into the legal weeds right now so much because there's just so much of it, right? But, as it eventually hits courts of appeal, I'll cover the courts of appeal decisions as they inevitably happen. And even potentially district court decisions. I won't cover like just injunctions because those are so preliminary. But if there's a final decision on the merits from a district court, I'll probably cover that. And certainly if there's a final decision on the merits from a Court of Appeals, I'll definitely cover that because, of course, I want to know what the law is, and so do you. And that's really interesting. So, it's all fun. Trump went off on Zelensky. Wow. Legal problems are coming from those black robe unelected activist judges. I wouldn't go necessarily that far. I think that's an overstatement, to be honest. There are non-trivial concerns about some of these issues. Now, I do, as a matter of personal as a matter, I suppose professional, as a matter of professional concern, I am concerned with these universal injunctions. I've been concerned about those for a long time. That is not a new problem. I've talked about that before on stream. Like the fact that a district judge can issue a nationwide injunction is a little odd, right? District judges oversee their district. There are 94 districts in the United States. They oversee their district. That's what they do. So it's a little odd that a district judge, which oversees their district, can issue an injunction that has nationwide impact, right? I mean, what is the basis of their authority? What is the basis of their jurisdiction, right? Is not really clear here, right? It's not really clear. Now, these ideas are not new. It's not like something that just happened just now. Well, it depends when you're measuring by. Like universal, global, nationwide injunctions, depending on what label you put on them, only started popping up, I think, in like the 60s or maybe 70s. So in legal time, it's relatively new. And they've definitely been used more expansively, at least since the Obama administration, I think, than even then. So it's a bit of an issue. But at some point, the Supreme Court probably needs to step in and say what the rules are here, right? I mean, the Supreme Court can do it as an exercise of their supervisory authority, if nothing else. So the Supreme Court probably just needs to say, like, what are the rules? Can a district judge do this? I mean, I don't know. But it seems a little odd that you can just basically run off to one of any 94 districts, find the one that's most favorable to you, and get an answer that applies nationwide. That seems a bit odd. So maybe that should be the rule, but the Supreme Court should probably clarify that at some point would be nice. But that being the case, however, I don't think you can necessarily say that these are activist judges in all situations, right? There are significant legal issues with some of these issues, as I've noted, right? And there are issues under the Administrative Procedures Act. There are issues relating to the Constitution. There are issues relating to many things where it's like, it's not clear that, necessarily the administration can do all these things. So, it's, I just, if you put me as a judge, I might be issuing injunctions with respect to some of these things because I don't know, because obviously I'd have to look at it, in obviously clear detail to know for sure. But it's like, you can be very conservative and have questions relating to some of the things the Trump administration is trying to do as it relates to law. So, some of them are activists, some of them are, but it's not necessarily clear that that's the case in all situations. There's a question of how much the APA defies constitutional authority. Well, the APA has been generally upheld many times. I mean, that issue has been raised many times in court, as I'm sure you appreciate. It's not the first time that someone's tried to say, is the APA constitutional? And yeah, I mean, it's been upheld many, many times. So if your question is the APA, broadly speaking, constitutional, the issue is yes. If the question is some specific provision in the APA, maybe those are not constitutional, but overall, the statute's valid. I mean, plus, of course, constitutionality is presumed as a typical rule by the courts, and they try to avoid constitutional issues when they can. The POTUS is the overseer of clearance. That's true. Yeah, the president can revoke someone's clearance. That's fine. And there's even Supreme Court case law on that. There was that case from that Navy guy who had his clearance yanked, and that went to the U.S. Supreme Court. And the U.S. Supreme Court's like, yeah, there's no due process for that. So yeah, revoking someone's clearance, no problem. Yeah, you can do that. You can do that on a whim, essentially. Yeah. Separation of powers absolutely comes into play for Trump, 100%. Yeah, 100%. It comes into play. Can he unilaterally grant it? Yeah. 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 Can the president do it? Sure. Yeah. The president can just give someone a security clearance. Yeah. He's the president. He is the original classifying authority. Yes, the president can just give someone a clearance with no investigation of any kind. Yeah. The president can just classify and declassify things on a whim. Yeah, he can do that. He's the original classifying authority. That's horrifying. Okay, I'm not sure why you think it's horrifying, but it is the law. Well, I'll tell you why it's not necessarily horrifying. I'll tell you to some degree why it has to be the rule. I'll tell you to some degree why it has to be the rule, and maybe you'll find it less horrifying, okay? All right, suppose that the United States has conducted a clandestine military operation somewhere in the world. And suppose that this military operation has gone wrong in a very horrible way, right? You can imagine your own scenario here, right? Like, you know, take your pick, you know, civilians are dead, you know, we hit the wrong target, you know, we bombed an embassy, you know, just imagine your own parade of horribles for how this operation has gone catastrophically wrong, right? So imagine the ambassador for whatever country, you know, this happened in is in the Oval Office and be like, can't help noticing, you know, that, you know, 300 civilians are dead and our embassy is bombed, you know, what's up with that? Now, if this is a clandestine military operation, it probably is clear that this is obviously very, very classified, right? This is extremely classified because, you know, it's a clandestine military operation, you know, done by black ops, blah, 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 right? So obviously it's classified. Now, if the president needed to go through some particularized process to go through declassification, that would be a real problem, right? That would be a real problem because the president needs the flexibility to make the choice to be like, you know what, that was us, our bad. Right. And so the president might be like, yeah, that was us, our bad. Sorry about that. Also, let me tell you about the military operation in more detail, which obviously is classified, but the president has to have the flexibility to do that so that he can tell the ambassador if he thinks it's in the best interest of the United States to try to save this cataclysmic situation. So obviously the president needs the authority to just be able to declassify stuff so he can do that. So that's the non-horrifying reason. He needs the ability to you know say, yeah, that was us, our bad, sorry about that one, and you know take responsibility. So yeah, that's obviously a good thing. Yeah, I don't think it's horrifying at all that the president can do that. I think it's a very good thing that he can do that. That's a good thing for the president to be able to do. That should be a choice that's available. Maybe the president shouldn't do that. Maybe he should deny it. Maybe a lot of things. But like one of the options probably needs to be, I'm going to confess. That probably needs to be one of the options. Have you seen breaking news of the White House out of Ukraine? No. What is the breaking news? What else is happening now out of the White House? It's hard to keep track of, man. Shouting match? I've heard about the shouting match. The shouting match is fun. Yeah. Or for example, like the declassification of all the, you know, MLK, President Kennedy, Epstein files, and so forth and so on. It's like, yeah, I'm, you know, that seems like a good thing for the president to do. It's like, yeah, he should be able to say those things are no longer classified. Here's the secrets. So that's good. All right, guys, I think I'm going to sign off for now. So I'm not sure what we're going to do in terms of our immediate future. Maybe we'll do a stream in like a half hour or something. I need a slight break. Obviously, between streams would be helpful, but maybe we'll take like a half hour and then maybe we'll look at the shouting match because that's in the news and we'll take a look at that and see what it says about things that might be fun to do a reaction to. So I guess anticipate that we'll be on in about something like a half hour or an hour, and we'll discuss this shouting match. And then as time may allow, we'll try to get to the Commonwealth's response in the motion to dismiss and Karen Reed and go back to that. That'll be fun. And we'll discuss that some more. All right, guys, I will see you a little bit later. Until later, my friends, I've been Uncivil Law. I hope all's well for now. Cheers, my friends, for now, and goodbye.